Hey everybody, welcome back to This Week in Immigration, wrapping up what has been an incredibly busy time in immigration policy. We'll sift through the headlines to tell you what really matters. I'm Jordan Lapierre. This week on the program, we look at action from all three branches of the government, the administration's zero-tolerance policy and family separations at the border, the House votes on immigration legislation, and the Supreme Court's ruling on the travel ban. All that and more coming up. But before we start, remember, subscribe, rate, review, and share this podcast on Apple Podcasts, Google Play, Stitcher, or wherever you get your podcasts. You can also stream on our website at bipartisanpolicy.org. And while you're there, you can check out bipartisanpolicy.org/immigration for more information on the stories we discuss here on the show. All right, it's been a busy couple of weeks, so let's not delay any further. Here today are the usual gang: Theresa Cardinal Brown, Director of Immigration and Cross-Border Policy.
Hi, Jordan.
Cris Ramón, Policy Analyst.
How's it going?
And Laura Hall, Senior Manager at BBC Action.
Hi there.
So let's start as I said, we've got action from all three branches of the government. So let's start in the Supreme Court. As their term wound to a close, we finally got a decision on the third iteration of President Trump's travel ban, and the court voted to uphold it. We've covered that ban a lot on this podcast, so you can go back to some of our previous episodes if you want to know more about the details. But now we've got the final word. So, Theresa, what was the court's reasoning in their decision?
So the majority, the five justices who upheld the president's travel ban, the major reasoning in their decision was that Congress granted the president extremely broad authority to determine when to stop people from coming into the country. And that exercise of the authority, at least in this version of the travel ban, was justified by the president's authority in national security and foreign policy. They did look at the plaintiff's arguments about whether or not the president's statements about whether this was a Muslim ban or not were relevant. And they basically said it's not the court's decision where there's another facially valid reason for this action to go behind that and look at the prior statements. So they upheld the ban. It's fully in effect now and has been for a while since they lifted a previous injunction.
So I should say, though, this was a 5-4 ruling, so there was quite a bit of disagreement among the justices, and there were four who dissented from that line of thinking. What was their position?
So there were two dissenting opinions. The first, with Justice Breyer and Justice Kagan, said that in order to determine whether or not this proclamation or the travel ban was motivated by anti-Muslim bias, one of the things that the court should have looked at was its application. So, for example, in this version of the travel ban, there's a lot of information about how people can apply for waivers, but there's been some evidence in the public that very few of those waivers have been granted. And Justice Breyer's dissent says the court should have looked at its application, not just its facial reasoning. Justice Sotomayor was more explicit. She said that any reasonable observer looking at the statements of the president and how this was put together would decide that it was based on anti-Muslim animus. And she was just joined by Justice Ginsburg in that decision. It's worth noting that Justice Kennedy agreed with the majority. He had a very short concurring opinion that basically said, even though this court may not be able to say that this action was unconstitutional, that all public officials in their official capacity, whether or not what they do is subject to jurisdiction of the courts, should act in accordance with the Constitution. It seemed to be a statement aimed at the president.
I want to come back to Justice Kennedy in a few minutes.
Yes.
We've got some other important news about him to discuss, but first, what about precedent? Does this decision set any precedent moving forward?
Well, it certainly makes clear that the president's authority in immigration is extremely broad and not very constrained in any way. As long as there is a facially valid linkage to a national interest, in this particular case, national security, the president has extreme authority to bar individuals, classes of individuals from entry to the United States. And I think that even though that authority has been exercised rather narrowly by past presidents, this president seems inclined to expand that.
So with the travel ban then now fully operational, what changes, if anything? I mean, this has been the law of the land for a while.
It has been, and I think that we've already seen since the third travel ban went into effect, at least one country was removed, and that was Chad, so that there is a sense that as countries improve their information sharing with the United States, other countries might be able to come off. But it has been implemented, and we're already seeing impacts. U.S. citizens from these countries who have family members from these countries and still in those countries have been unable to have them join them, and that's creating hardship for them for sure.
Will this decision give the administration latitude to take additional steps with respect to a travel ban?
Well, as I mentioned, it certainly gives the president broad authority. It's unclear at this point what other directions he might go. There's lots of supposition. He's talked a lot about criminals and criminal gangs, so theoretically that's a place he could go, but we have to wait and see.
So you mentioned Justice Kennedy, and of course the other big news out of the Supreme Court is that he has decided to retire later this summer, and so that opens up a new Supreme Court fight, and there are some implications for ongoing DACA legislation. And Cris, you tweeted something interesting earlier that I want to ask you to sort of explain here on the show.
So basically what happens is, as we've been discussing about DACA litigation, it's winding its way through the courts, and there have been two decisions from federal courts that basically state, one, you have to renew, DACA renewals can go through, and then the second one that said initial applications can go through. But there's also a new challenge to the lawsuit, to the program that various attorney generals from red states filed with a court in Texas. That decision is still making its way through the court. They're going to be deciding. What's important, and what we've mentioned before, is if the decision that comes out of Texas says the program's unconstitutional and must be ended, you'll have two competing nationwide injunctions. Okay, so what does this mean with Justice Kennedy stepping off? Well, if he steps off, we're going to have an 8-person bench. And in an 8-person bench, as we saw, the last couple of years, is a 4-4 decision means that the lower court rulings stand. So if Texas comes out with this decision, and DHS essentially has to appeal to the Supreme Court before the next judge is confirmed, we're facing a potential situation where you may have a 4-4 split decision. Those two nationwide injunctions stay in place, and chaos ensues. I mean, to put it bluntly,
yeah.
I think that's really the point, that right now, because of the pace of where this litigation is going and the pace of we're unsure when the nomination is going to go through, this could make things a little bit dicier for that set of litigation because of Kennedy's announcement.
I want to dive into that a little bit more in a future episode, because I think that's incredibly fascinating looking ahead the next few months. Let's move over to Congress now. Last Wednesday, the House failed to pass a more moderate plan on DACA that had been pushed by Speaker Paul Ryan. That came after a vote the previous week on a conservative bill, the Goodlatte bill, failed as well. Let's start by unpacking both of those votes. Laura, the initial plan was to vote on both of those bills in the same day.
Yep.
The Goodlatte bill went first, and it came up short. And that probably wasn't a surprise.
Right.
But maybe it was a surprise that it got so many votes, and it got relatively close to passage. What happened there?
It did. Yes, so the original plan was to vote back-to-back, essentially allowing members to vote on two different options. They were set up as individual votes, so people could vote for one, both, or neither. And the Goodlatte bill did get more votes than people expected. I think the final vote there was 193 to 231. The bill had a support from a good chunk of the House Republican Conference. There were some moderates that didn't support it, 41, along with all of the House Democratic caucus.
So, and then instead of putting forward the Ryan bill, as had been the plan, House leaders pulled that back and delayed for almost a week. What was behind that decision?
Yeah, I think after Goodlatte failed, the Republican leaders wanted a little more time to have the second bill pass, basically, and get over the finish line. So they wanted a little more time to kind of talk to folks, figure out what they could do to tweak that second bill to get it in a place to get it to pass. That's always a risky proposition when you're dealing with a piece of legislation that has such razor-thin margins like this one did. Putting off a vote on one hand gives you time to kind of bring some more people into the fold, but also gives you a little time for some of the folks that maybe were in the yes column to get cold feet and move off the bill, which is kind of what happened.
Previewing exactly what went down on Wednesday, the Ryan bill came up for a vote, and it didn't do that well.
It did not. No.
What's your sense of what happened?
The compromise bill was defeated, 121 to 301. All Democrats and most conservative Republicans ended up voting against it at the end of the day. Even some of the conservatives who had been at the negotiating table trying to get this bill across the finish line. I think what happened is conservatives just didn't really feel any pressure to come to the table on this anymore. They knew they had the upper hand with the moderate lawmakers. The discharge petition that at one point had been in play to kind of force this on the floor was rendered moot by the vote on Goodlatte, so that wasn't part of their bargaining apparatus anymore. The conservatives kept demanding a higher and a higher price for their votes, and moderate Republicans just couldn't stomach it anymore at the end of the day. I think the White House also made things a little more difficult. You saw a seesawing back and forth between President Trump encouraging the House to vote on something, President Trump changing his mind and saying they should abandon the issue and move on to other topics. I think if maybe you're a Republican who wasn't sure where they were going to go on this, feeling like the White House didn't have your back on something, encourage them to maybe move on and not offer their support at the end of the day.
Yeah, so in a lot of respects, this looks very similar to the experience the Senate had earlier this year in terms of how everything played out. So I'll put this question to both you, Laura, and you, Theresa. Mm-hmm. Does this mean that there simply isn't a majority in either house of Congress for significant immigration legislation this year?
Yeah. The one thing that I will say, the thing that is different in the Senate is that a lot of those bills were discussed and voted on in a bipartisan manner. The House, they were party line votes on both sides. But I think what it does tell you, the numbers just this has to be a bipartisan issue. The Senate couldn't quite get there, even though they tried to do things bipartisan, but there's no way to get there if you're just dealing with your own party. The Democrats don't have the numbers, the Republicans don't have the numbers, whether it's a more conservative plan or a more moderate plan, passing it with just the votes of your own party isn't going to happen, as we saw play out in the House this week. So there has to be discussions continuing along what the Senate started about bringing people together from both sides of the aisle.
The only thing I would add to that is, yes, this set of bills that were discussed in the House were Republican-only bills. When Paul Ryan was elected Speaker, he made a promise to the House Freedom Caucus that he would not raise immigration legislation unless it had a majority of the majority, the so-called Hastert rule. Well, this bill, the compromise bill, did get a majority of Republicans. It didn't get a majority of the House just from Republicans. And I think that's the important thing to say here. If it had been a bipartisan bill, could it have gotten more than half of the Republicans and more than half of the Democrats, and therefore more than half of the House? Possibly. And I do think there's a bill out there that could do that. The problem is that majorities tend to want to try to get the majority from their majority. And that's a higher bar. That's a lot harder, particularly in the Senate, where you actually have to get 60 votes and Republicans only have 50. So they have to get some Democrats on board, and they have to be able and willing, frankly, to lose some of their own votes to do that. That is something that leadership doesn't like to do. And I frankly think that Democrats, when they were in the majority, were in the same boat. They didn't like to do that either, because it means giving up some control over the process to the other side. But again, with big bills like this that are challenges for both sides of the aisle, that's the only way to actually get it done.
Well, I guess the big question remaining is, what happens now? Is this the end of immigration legislation this year? What's your sense?
I don't think so. I mean, certainly the DACA issue is still to come out. As Cris mentioned earlier, there's court cases that are going to be proceeding. And I think if that does devolve into chaos, or the Supreme Court weighs in and ends the program, Congress may feel the need to try to act again. And then there's other issues that they're trying to address. While this all was going on, the family separation issue kicked up.
Right.
And so Congress is now trying to figure out what they want to do on that piece.
Yep, we've got an effort underway in the Senate between Senator Cruz from Texas and Senator Feinstein from California to try to forge some kind of bipartisan legislative answer to the family separation crisis. I don't think any formal announcements about their path forward have been made yet, but I think you will see members trying to figure out something on the family separation issue. For bigger immigration issues, it remains to be seen. We had the partisan effort that wasn't successful, the bipartisan effort that wasn't successful. Do they have the appetite to try to tackle this one more time?
Well, and as you were saying earlier, we don't know what external events might
force them to kind of come to the table on this. Yeah. So stay tuned.
Okay, thanks. Finally today, the executive branch. Since we last talked, the world was captivated by that ongoing story of family separations at the border, and President Trump signed an executive order purporting to end the practice. What does that executive order, Theresa, actually require the government to do?
Well, the executive order stated that the administration would no longer separate families, but it also stated that they were going to continue to prosecute immigrants for illegal entry, the so-called zero tolerance policy. That sets up a bit of a challenge for the government, in part because, as we've said before, once you prosecute somebody in criminal court, usually they are remanded into criminal custody and the kids can't go with them. So now the administration is trying to figure out if they can continue with the criminal prosecutions while maintaining the family together in immigration detention. But there's some legal reasons why they may not be able to do that. The Flores settlement remains in effect, and they may not have the room. That's a big issue. And so we have seen now in the last week where the administration has admitted that they're not going to be prosecuting everybody. Customs and Border Protection has said, we're not going to refer everybody because we don't have the places to put them. And they're reaching out to every other government agency they can to try to see if they have places to put people.
Cris, I want to bring you in on this as well, because I know you've done a little bit of work on this. What's your sense of whether the order actually does end separation of families?
I mean, it's a little bit unclear, right? I think leading up to this, when people were saying, end the separation of families, a lot, at least for the advocates, they wanted the end of zero tolerance. That policy, like Theresa was saying, led to the criminal prosecution of parents. Parents would be put through criminal proceedings, the children would be put through immigration removal proceedings, and so forth. And I think that's what you saw the advocates really wanting. But what the president's order does is essentially it keeps zero tolerance in place, but families are maintained together in detention. So really, it's a question of what do you mean by family separations, right? Are you saying you want to end the zero tolerance policy that leads to families being separated in that way, or are you what the administration is basically saying is we're going to quote unquote end family separations, but by keeping them in detention through the criminal and immigration proceedings. And that's what the administration is saying it's doing. But that's why I'm saying it's a little bit unclear, because it's really, what are you defining as family separations and what are the practices leading up to that? So I think it's unclear, depends on who you talk to about this.
So while we've been trying to sort out what exactly the effect of that executive order is, a federal district court judge issued a strongly worded injunction against family separations. And what, Cris, did that order say, and how does that impact the government's actions at the border?
So what the court said, there were two things that the court said that then justified the decisions that it made, which is essentially said that the government has to stop family separations at the border. Parents and children have to be released together from custody and during removal proceedings. And it requires the government to reunify families. If you're under the age of 5, you have to do it within 14 days of the court being issued. And if you're over 6, you have to do it within 30 days. Now, why did the court say this? The court said two things. First of all, they said that although these individuals are arriving to the U.S. border and these individuals tend to have very few rights, it did say that they do have the right to family integrity at the border, especially if they come at ports of entry and they present themselves for asylum, which is what the case was sort of deciding on, this case of an individual who came to the United States from a country in Africa and then was removed from her child. So that's one of the justifications. But the other thing that the court went into in a very deep dive and very critical one of how the government really does not have procedures for reuniting the families, for establishing methods of communication between the separated children and their parents. The court literally said there are better procedures for tracking the property of individuals who are put in prison than there are for the children of those separated from their parents. I mean, that's scathing. But yeah. I think that those 2 points of what the court is arguing justifies what it's been ordering. But I think particularly that point on property versus children, I mean, that's blistering.
Yeah. So it leaves me wondering, though, where does this leave the administration's zero tolerance policy? It feels like they're really caught between a rock and a hard place right now.
Yeah. So as I mentioned, by de facto, if you will, the zero tolerance policy is done. Department of Justice has asked the judge in the Flores settlement to permit them to detain kids with their parents indefinitely during the pendency of their hearings, as opposed to separating them. But unless or until the judge does that, all children have to be released within 20 days. And if they intend to continue to detain the parent, that means separation. So if the president's order means anything and you're not separating families, they will have to be released. And that's essentially what we're hearing the government is doing. At the same time, the government is desperately trying to say, no, we've got the kids who have been separated covered, and we have ways of doing this. But as Cris mentioned, the judge isn't seeing that. And frankly, individuals who are working with these families to try to reunite parents and kids are not seeing that yet. And I would just go back to something that I think we said earlier. This was a policy that was designed and implemented in the White House very, very quickly without input from the agencies that have to operate it. So we saw that with the sort of the chaos initially with the zero tolerance when it was implemented, and we've seen it again since this executive order was signed very, very quickly. The agencies are playing catch up, trying to figure out how to implement this order with a set of constraints that don't allow them to implement the order, and what do they do about it. And I go back to, even if the administration is going to be able to, for example, get the judge in Flores to say, yes, you can keep kids and families together in detention, they don't have enough space. There's clearly not enough family detention space that they have. So they're reaching out. HHS, for the number of unaccompanied kids they have now and will continue to get, is looking for additional beds from the Department of Defense. DHS now is looking for additional family places to stay, again, from the Department of Defense. This was part of the executive order. But they're also going out to private sector contractors with requests for information about anybody who can help them. They're desperate to try to do this, but they're still playing a lot of catch up.
And I think the thing is what Theresa said earlier, with the absence of enough space, they're going to have to eventually start reverting to what they call catch and release. And the greatest irony of this is zero tolerance was adopted to end catch and release. So literally, by the fact that the administration wants detention, you can argue about whether that's effective as a deterrent or not, but if you need detention, if you want to pursue detention, you need spaces to hold people in them. Without enough spaces to hold people in them, you have to release them. And it sort of creates like this little like vicious cycle of just simply you can't support zero tolerance policies. At that point, it's just tolerance policy. There is no zero.
So we've been hearing a lot of people talk recently about alternatives to detention, and we won't get into that today, but I think we should jump into it in a future episode.
Absolutely.
What are some of the ways that the administration could choose to try to keep track of these folks if they have to release them, if they can't hold them indefinitely? But I want to turn today quickly to President Trump's attacks on the immigration court system. Several times recently, he's tweeted that immigrants should be deported without going through immigration judges, and he's alleged that the system is corrupt. This seems to be opening up a new front in the illegal immigration debate, so let's unpack it a little bit. Theresa, can the president deport immigrants without a judicial hearing?
So some immigrants under immigration law can be deported without a judicial hearing. It's a process called expedited removal. It applies to immigrants who arrive between ports of entry and are apprehended unless they ask for asylum or indicate an intent to ask for asylum, in which case they cannot be removed without a hearing. They must be referred to asylum officer, and then if that pass a credible fear, an interview to an immigration judge. At ports of entry, similarly, if somebody comes to a port of entry and asks for asylum, they must be referred to an immigration judge. If they are inadmissible, they don't otherwise ability to enter, they can be removed via expedited removal. There are some other provisions of law that allow certain people to be removed without a hearing. For example, if they had a hearing previously and were removed and came back, that previous order of removal can be reinstated and they don't necessarily get to go to a judge again. And certain people convicted of what are called aggravated felonies. But the more important thing probably to say is that the president can't unilaterally get rid of immigration courts either. All of these processes that I've described are set forth in statute. And so the executive branch really doesn't have discretion to choose whether or not to send somebody to an immigration court if the law clearly states they're entitled to go. And so I think that's something that needs to be said. I think the president is trying to express his own frustration with the limits of the ability of the executive to address immigration flows. We go back to why was zero tolerance put in place? Well, zero tolerance was put in place for the same reason the administration wants family detention, because they want to try to deter people to coming. Why do they think they need to deter people from coming? Because the process says if you ask for asylum, you have to be sent to an immigration judge, and the immigration courts are very much backlogged, which means that most immigrants, if they're not immediately returned, have maybe a 2-year wait before they see an immigration judge. For an immigrant who's coming from a tenuous circumstance in Central America, 2 years to make their case before an immigration judge sounds like an attorney. That's great. I'll have 2 years to figure it out. In the meantime, I can work. Me and my kid are safe. That's great. And the administration sees that as an incentive for more people to come. But instead of addressing that, they're trying to figure out, how do we do things to deter people from coming in the first place? How do we detain them? How do we separate them from their kids? How do we ensure that we can remove them as quickly as possible? And I think that's the reason he's saying that we don't need immigration courts. He wants people removed quickly.
So you mentioned this a little bit, but let's expand on it a little bit more. Theresa, you and Cris wrote in Roll Call last week that immigration court backlog, that 2-year delay, is the real issue, and that if you want to effectively address the situation at the border, you've got to find a way to reduce that backlog. So you mentioned 2 years. Is that kind of the average?
That's the average. It's greater in some locations than others, yeah.
And how can we effectively address that problem?
Well, the initial thing is probably hire a whole lot more immigration judges. And the thing to understand is one question to ask is, how do we get in a situation where it takes so long to hear and get to an immigration judge? And it's a confluence of factors. One is, at the same time we have been building up the border security apparatus and throwing a lot of resources and people at the Border Patrol and the U.S. Mexico border, we have not concurrently increased the process on the backside of that results in immigration decisions. Kind of like if you increase the number of cops on the street and make 10 times more arrests, but don't increase the number of judges to hear those cases, the courts will get backed up and it will take longer to hear those cases. That's exactly what happened here. And the change in who's arriving. As I mentioned, Central Americans applying for asylum have a right to an immigration court. Previous waves of immigrants have been mostly Mexican men who didn't apply for asylum, so a lot of them didn't go to immigration court. So the demand on the courts has gone up, the resources remain stable, and that's where we are. The number one thing that could be done to decrease that backlog is hiring a lot more immigration judges as quickly as we can.
Yeah, and I think that's really the core thing. If you have more individuals to process these cases, you'll have the backlog decreasing them. I think we had an estimate that right now, with the current levels of judges, this backlog won't end until 2040. That's a long time to have that. And so if you don't reduce that backlog, the incentives for people to continue coming here because they think, I've got 2 years to make a life here, is going to keep being there. So this is a really important issue for sure.
So I'm left with the question of why focus on immigration courts now? Why is the president focused on the immigration courts now? Beefing up that system is one place that seems to have had some bipartisan consensus, a small place of bipartisan consensus. So do the president's comments then just blow up that dynamic?
Well, every time the president makes a comment, I'm sure it makes people of his own party nervous about what to pursue. Laura mentioned that when it came to the House bill. That having been said, I think a lot of the people who are looking at this situation understand the importance of the immigration judges and how it can impact this overall thing, and may not take the president's tweet at face value. So I think we are going to see this becoming more and more part of the conversation.
Okay, well, thanks to all of you for being here. That's our show for this week. And thanks to you for listening. And a special thanks to our producer, Emily Schrader. Please take a second to find us on Facebook by searching Bipartisan Policy Center, or on Twitter at BPC_bipartisan. And don't forget to subscribe and leave your feedback on this podcast on Apple Podcasts, Google Play, Stitcher, or wherever you get your podcasts. Just search Bipartisan Policy Center. Join us again next time.